Just some handling matters to start with. In the event of a fire alarm, members should leave the room by the marked fire exits and follow instructions from the ushers and staff. There is no test forecast for today. All mobile devices are switched to silent. The National Assembly for Wales operates through both the medium of the Welsh and English languages. Headphones are provided through which instantaneous translations may be received. For any that are hard of hearing, these may be used to amplify sound. Do not touch any of the buttons on the microphones, as this can disable a system and ensure the red light is showing before speaking. Interpretation is available on Channel 1 and verbatim on Channel 2. There are no apologies. We have a full committee with the exception of the one vacancy that we have at the moment. And I'll now move on to item 2. Instruments that raise no reporting issues under Standing Orders 21.2 and 21.3. Negative resolution instruments. The non-domestic rating small business relief Wales order of 2017. There to note any comments on this? Any issues?
No comments.
Okay, we'll move on to item 3 then. Instruments that raise issues to be reported to the Assembly under Standing Order 21.2 or 21.3. Negative resolution instruments. The ringing of certain captive bred birds, England and Wales regulations 2017. You have before you a copy of the order, explanatory memorandum and report. These regulations implement certain obligations under Articles 2, 5 and 6 of the EC Directive on the conservation of wild birds relating to the ringing of birds bred in captivity. There is an issue that's been raised, but with regard to the format, the regulations have been made in English only. Are there any comments from the lawyers?
No, just to say that there is a reporting point that we make under standing orders. They are composite regulations, and again, the reason given is that it's not possible to scrutinise composite regulations bilingually. As I understand it, this is a matter that's been raised on several occasions in the past, and that we have got evidence of legislation that has been made bilingually. So I guess it's another one to report and to see whether we have a government response on it.
Members have been given, I think, a copy of this letter the 15th of January 2018 to Derek Twigg, MP, Chair of the Statutory Instruments Committee of the House of Commons. That sets out our concerns over this. I think there's another matter later on the agenda that relates to the same matter. So I have raised it formally and will report back to this committee on really what is an unacceptable position at the present time. I now move on to the affirmative resolution instruments. The Landfill Disposals Tax Administration Wales Regulations of 2018. And in front of members is the order, explanatory memorandum and report. And the Landfill Disposal Tax Wales Act establishes a new tax to be known as the Landfill Disposals Tax. The tax is to be charged on taxable disposals as defined by the Act. Invite first any comments from the lawyers.
There aren't any technical points on this one, but the merits point that we did raise was the fact that there are certain definitions not given on the face of the statutory instrument, which legal services think that would be helpful to the reader. Now, legally, it's not legally required because by virtue of the Interpretation Act 1978, if there's a definition in the Parent Act, then you read it over to the secondary legislation that comes under that Parent Act. We have had a government response in this afternoon, actually, just shortly before the meeting, to say that there is no legal requirement for them to put these definitions on the face of the SI, and they make the additional point that if they were to start putting definitions in every SI, then that would perhaps muddy the water or make it unmanageable.
So much for trying to establish clarity in our lawmaking.
I mean, we agree that there's no legal requirement for it to be put on the in the SIs themselves, but it would help the reader so that you wouldn't have to refer back to a Parent
It's all in
Act.
the same place. I mean, that's what we've established, isn't it? So you wouldn't have to refer back.
there is before you, as you see.
It's a
there
real
is-
process, dull, bureaucratic
Yes.
response, isn't it? Let's face it.
There is, as I say, there is a two-paragraph response which is there. I suppose the only interesting point to note, of course, is although there's reference to the Interpretation Act of 1978, government's already indicated its intention to bring forward its own Interpretation Act, and that brings forward the issue as to the clarity and the basis for interpretation within Acts. I'm sure this is a matter that will come before us, hopefully in a way in which we can resolve some of these, I suppose, bureaucratic problems. Are there any other comments on this, other than what's been already noted? In that case, we move on to the, I think, what are we on now? We've just completed that one, haven't we? Yeah. So we're now on to the composite negative resolution instruments, the Environment Permitting England and Wales Amendment Regulations 2018. The same point, I think, arises in respect of the use of the Welsh language I referred to earlier. Are there any other comments from lawyers?
Only interestingly in this particular SI that these regulations actually do amend bilingual legislation in some places, and when they do that, they do it bilingually. But therefore, there's obviously the ability to legislate bilingually when it's needed. Nothing else to
The
add.
capacity is there, but the spirit is not necessarily willing. Okay, well, as I say, we have written to take that
Worth
issue.
noting that important point, though, because obviously
Absolutely.
they're not averse to the idea.
No, absolutely. Move on to item 4, instruments that raise no reporting issues under Standing Order 21.2 or 21.3, but have implications as a result of the UK exiting the EU. So we have the Agricultural Holdings Units of Production Wales Order of 2017, and there is a report before members. This order prescribes units of production for the assessment of the productive capacity of agricultural lands situated in Wales and sets out the amount which is to be regarded as the net annual income from each such unit for the year 12th of September 2017 to the 11th of September 2018 for certain purposes of the Agricultural Holdings Act 1986. Are there any comments lawyers wish to make on?
Nothing to add really to the report. There are no technical or merit points, only implications arising out from the exit from the EU. In this particular order, there's a definition for eligible hectare, which is very important in terms of this order. Because it's part of a regulation, comes from a EU regulation, after EU exit day, the powers to anything in relation to the definition, for example, here, would be retained by UK ministers and UK Parliament. So even though it's within a devolved area, we won't have any power to do anything, to comment on it. So the UK ministers will be free to amend.
Yes. So obviously
in
subject
future.
to whatever amendments are made to the withdrawal
Yes.
bill.
Yes.
Any comments?
Or a continuation bill,
Or
presumably.
absolutely? Well, that's yes. It's another matter not before us at this moment in
indeed.
time.
No,
but
just
obviously-
flagging it up, Chair.
Absolutely, absolutely, as you're entitled to do so. If there's no other comments on that, then item 5, papers to note, there is the Welsh Government statement on the Welsh Government Prosecution Code to be noted.
Noted.
Obviously, the important constitutional step forward. Trade Bill Legislative Consent Memorandum. The LCM was laid on the 7th of December 2017. The Business Committee has also has referred this to other committees for consideration as well. Maybe this is a matter that we want to consider in private session later on.
Okay.
Okay, then we move on to item 6, Public Service Ombudsman Wales Bill, Evidence Session 1, which is with the Cabinet Secretary. Can we bring in the Cabinet Secretary? I welcome the Cabinet Secretary to the meeting of the Constitutional Legislative Affairs Committee, session on the Public Service Ombudsman Wales Bill. And to remind members, this is not the Cabinet Secretary's bill. It's not a government bill, as one brought forth by the committee itself. But obviously a matter of importance. Do you want to introduce your officials, Cabinet Secretary?
Chair, thank you very much. So, Nick Howard is a member of the Legal Services side of the Welsh Government and providing me with legal advice in relation to the bill, and David Richards, who is leading in terms of the policy issues that the bill contains.
Thank you very much. I know you've given evidence, obviously, on this bill to other committees. Our interest in it is really more to do with the technical aspects of the bill. Perhaps just as an opening question, a starting question, what your overall view is of the bill?
Well, Chair, I think the Welsh Government's position is that we have offered the bill qualified support, caveated support on introduction. If you think of the bill as having four main aspects, then we are broadly content, subject to some relatively minor points with what the bill proposes in relation to a new ability for the Ombudsman to take oral complaints and the ability of the Ombudsman to pursue the privately provided aspects of a healthcare pathway that involves the Welsh NHS as well as the private provider. We've had some greater questions in relation to the other two aspects of the bill, although it's important for me to say our starting point is not that we are opposed to them, it's simply that we think they merit exploration. So we've had some questions to ask, particularly in relation to the own initiative proposals, which are new and would be the first time that the Ombudsman in Wales had such powers, and in the standard setting aspects of the bill. And I explored those from a policy perspective with the Equalities and Local Government Committee, and will look forward to hearing their conclusions when they've had a chance to take evidence from others who have an interest in the bill.
If the committee hadn't brought forward this bill, is this an area where you consider there is a need or has been a necessity for legislation? Well,
Chair, there was a discussion of that sort during the fourth Assembly term, primarily between my predecessor as Finance Minister, Jane Hutt, and the Finance Committee, debate being a little bit about who should take the responsibility for taking forward proposals that the Ombudsman's office itself had generated. I think at that time, the Welsh Government's view, and I think it was in the end shared by the Finance Committee, was that because the Ombudsman has powers to scrutinise the Welsh Government itself, that the Welsh Government was not best placed to bring those proposals forward. And the Ombudsman is, of course, accountable directly to the National Assembly. And for those reasons, I think our feeling at the time, and still would be, that the reforms are best promoted via a vehicle that belongs to the Assembly itself rather than to the executive side.
Yeah, thank you for that. So this is an appropriate way forward. One of the areas, of course, of the remit within this committee is the issue of competence. If I might just ask you, there's two aspects to that. Competence under the existing Government of Wales legislation, as opposed to the what the situation might be after the 1st of April 2018, this year, when the Government of Wales Act 2017 comes into effect. Do you have any concerns or issues with regard to competence?
Well, Chair, because it's not a Welsh Government bill, we don't have to ourselves. Much of the bill has provided the necessary Section 112 of the Government of Wales Act assurance that, in his view, the bill is within competence, and of course the Llywydd has also played her part in it and made a statement on the 2nd of October that, in her view, the provisions of the bill as introduced will be within the Assembly's competence, and the Government is happy to rely on on those assurances.
Okay, no, thank you for that. We will be obviously pursuing that point with the with Simon Thomas. Di Lloyd.
Thank you very much, Chair. Naturally, as you'll know, this committee only focuses on the legislation. We don't deal with policy issues with regard to this bill, as you'll know. So may I just ask you what implications you believe this bill could have with regard to human rights?
Well, of course, fel...
Well, of course, as part of the Llywydd's considerations when she considers the issues surrounding competence, then human rights is one of these issues that she would take into account. And she's made her comments on that side of things. As I see this bill, there are a few examples where the bill does more to support human rights by providing the ability to take complaints orally. I think that assists with the human rights of those people who aren't confident in submitting things in writing. There are certain things in Article 8 of the bill where the bill suggests a number of things that would protect personal data, and there are regulations on the face of the bill whereby people who share personal data with the Ombudsman's office can be confident that he won't then place that data into his published reports.
Aspect of the bill, Chair, where we might have some issues that we would want to discuss with the member in charge should the bill proceed beyond stage 1. And that's just in the issue of retrospective provisions. So in creating the new ability to take own initiative investigations, the bill allows the Ombudsman to look backwards in time as well as forwards from the point at which the bill becomes an act of the Assembly. There is no time limit in the bill to that retrospective ability. And I think you could argue that an untime-limited ability to go into the past could give rise to some human rights considerations, where, for example, if it were the health service, you might imagine that some of the issues being inquired into, the people who were involved in them would be no longer employed, either in the health service at all, or at least by the part of the health service that they were employed by at the time that the issue was at the time of the issue that is being investigated. So I think it's a question that we will just want to rehearse with the member in charge as to whether a long stop period. I believe the Ombudsman, as a rule of thumb, doesn't take up complaints that are more than 2 years old. Now, that's a sort of the way that the office operates. And I don't think maybe it would be unreasonable to think that a long stop period of that sort might allow the bill to work more effectively and to have some consideration of human rights issues that might occur in that context.
Yeah.
The issue of retrospection, but I'm not sure I understand how that would differ categorically from the current position where a specific complaint is made and then, you know, the past evidence is looked at. Why is that? Why is the fact that a complaint is, or potential complaint or a deficiency is investigated on the Ombudsman's own initiative different from a complaint that just comes and then there is this inevitable examination of the record? Well, from a human rights point of view, you know, the example you gave would apply as forcefully if it was a patient that had made the complaint.
I might just ask Nick just to say a couple of things.
Sure. We recognise that there are safeguards in the provision as it's drafted, in the sense that it looks backwards. It enables the Ombudsman to go back. But in order to do that, he has to be satisfied that there is still a risk of hardship or maladministration or systemic failure there. So we understand that that's there. I think our understanding is that in practice he does apply this 2-year rule. And I see the point about own initiative investigations, but maybe a general time limit might be appropriate.
But I still can't see how this is focused on the power of the Ombudsman's own initiative. It doesn't seem to be that creates anything new in terms of human rights issues that currently exist from complaints that are routinely referred to him.
You may well be right. And what I said was is that it was something
you want to explore.
We wanted to explore with the member in charge. I do think there are some material differences in the sense that if an ombudsman is pursuing a complaint that has been brought to his attention, then he is doing it at the initiative of the citizen who has a complaint to make. In own initiative investigation, the ombudsman is self-certifying. Yeah, if you look at the way that this bill is constructed, the person that the ombudsman has to satisfy that what he is doing is in line with the law is the ombudsman who is taking his own initiative. So, in that sense, maybe the tests of safeguards for others, you could argue, need to be of a slightly higher order than if he's not acting on his own initiative, but acting on behalf of someone who has made a complaint to him within the rules.
Can I just follow that? Because one of the areas that we specifically concern ourselves with is the issue of retrospectivity. And, of course, in the paragraph 5 of the bill and the talk about investigations being in the public interest, of course, one of the criteria in terms of what amounts to public interest is systemic failure. And it seems to me it's impossible to investigate systemic failure without going into the history of failures, which means you're immediately into the area of retrospectivity. So I suppose, I mean, it's unfair to press you on this point. I think we have to press the person in charge of the bill. But there is clearly an issue there in terms of these are very broad-ranging powers, and they do have retrospective issues that they raise, some of which exist at the moment. But I suppose the point is if you're extending the powers, the issue of retrospectivity comes more to the fore and something that needs to be looked at very, very cautiously.
I think that is exactly the sort of discussion we would want to have with a member in charge. It's not the government's position that there should be no retrospective ability for the Ombudsman. It's just that if an unfettered right to go back as far as you might ever want to go, I think the further back you go, some issues do become more prominent in the way you need to think about them. Now, as David said, they may be no different. Some of these arguments may not be different in relation to an individual case being taken up. But given that this is a new power, and given that this was raised in the consultation by others, we think it's worth a further exploration with him.
There is a further issue. I'll raise it perhaps when I know there's some further questions that Di Lloyd wants to ask first of all. I'll come back on something around that I'd like to ask about.
Okay, just
Thank you. Just another fairly general question, understanding that it's not you who is responsible for this bill, but with regard to the drafting approach taken with regard to this bill, do you have any comment about the decision not to amend the 2005 Act, the original Act with regard to the Ombudsman? That decision not to amend that and to pursue another bill?
Well, ni'n gallu weld...
Well, we can see a case where people may say, well, you could just return to the original Act and make amendments to it. But there are a number of reasons, I think, why it is more effective to have a new bill. First of all, it's an opportunity to provide the legislation bilingually, and that's important for us in Wales, because the original Act back in 2005 was drawn up in the Commons and the Lords, and it's only available in English. The second point is that in having a new piece of legislation, it will be possible to consolidate everything that is pertinent to the Ombudsman in one place, and that assists people generally in terms of accessibility. So, for me, I can see the rationale behind the Finance Committee's decision to proceed in this particular way.
Thank you for that. And the last question that I have is to ask whether you believe that the member in charge of this bill has the right balance between what to include in the regulations and what to include on the face of the bill. The traditional debate, of course, that we have.
Well, yes, I've heard that at this committee in the past and have had similar discussions. Generally speaking, I do think that the balance is right. I think it is important to strike that balance between what is on the face of the bill, whilst also having some flexibility in ensuring that the bill remains viable and can take into account future developments. So there are a number of powers where issues aren't on the face of the bill, and the bill does state that the affirmative procedure will be used almost always when things are made through regulations, and also more than half of those examples where the bill states there will be implications in terms of having consultations. I'm sorry, I just forgot the Welsh word for a second there, but with having consultations with the Ombudsman and with others.
Where there are regulation-making powers, not on the face of the bill, they are consistent with the same approach in the 2005 Act. So the 2005 Act, I think, is generally well regarded. It's thought to have worked well, and the bill contains the same basic formula that the original bill did. I think there is one issue, Chair, where we feel maybe it would be preferable to put something on the face of the bill, that at the moment the bill leaves to a power for ministers. It's a small example. So the bill tries to advance the position where consultation between relevant players is guaranteed to take place. It provides an order-making power which would allow the Children's Commissioner powers to consult and work with the Ombudsman. The Commissioner already has those powers to work with the Older Persons Commissioner, and the bill provides the Ombudsman with powers to work with the Children's Commissioner. I don't think we've completely seen the case for leaving that power to Welsh ministers to trigger. Would it not be simpler to put it on the face of the bill? Okay. And then the Commissioner will have those powers from the outset. And that might just seem a more straightforward way of securing what the bill sets out to achieve, and which, you know, the policy ambition of it we support.
Okay. Can I just ask one bit that follows on slightly from that? With regard to paragraph 4 of the bill, I mean, these are very significant additional powers that are going to the Ombudsman. One of the important issues with legislation is clarity, and of course we have a number of other investigatory bodies that have very clear functions to be carried out. Now, when an own initiative investigation takes place, the legislation as it's drafted requires the Ombudsman to basically consult whoever he thinks fit. But it's not more specific than that. Is that something that causes any particular concern in terms of, you know, thinking from this committee's angle, in terms of clarity as to what the legislation is and what the powers are?
Well, yes, Chair, I did raise this issue with the Equality and Local Government Communities Committee in saying that one of the things we do think we would like to see improved in the bill in relation to own initiative inquiries is that if the Ombudsman were to decide to embark on an own initiative inquiry in an area where another regulator already has powers, that it should be obligatory for the Ombudsman to consult with that authority, rather than he's given the ability to consult in the bill, but again, it's on his own decision as to whether or not to do it. And I just feel that it would make better sense to say whenever you are thinking of an own initiative inquiry, you ought to make sure that that other regulator is alerted to that intention, because they may have relevant information, they may already be involved in a piece of work themselves. One of the risks in own initiative inquiries is that they end up further complicating an already quite complex pattern of inspection and regulation in Welsh Public Services. You know, we're not opposed to the Ombudsman having the power in principle, but it's important that the Act constructs them in a way that genuinely adds to what's available already and doesn't create the unintended consequence of actually muddying waters and creating new overlaps and confusions, and guaranteeing that the Ombudsman would consult somebody else if they were likely to go into their area would help, I think, to avoid that risk.
Okay, David.
Yeah, and you know, as Dr. Lloyd said, you're almost here under false pretenses, really, aren't you? As you're not the member in charge. So, the traditional question of why are there so many Henry VIII powers, and how outrageous that you put them all in. But were you surprised that so much leeway is given to the executive by way of Henry VIII powers, which will obviously allow for the bill to be, or for primary legislation, you know, to be altered?
Chair, I've looked at the Henry VIII powers issue. If I'm hoping I'm getting this correct for you. As I read the bill, I think there are 9 examples of Henry VIII powers in the bill, 6 of which mirror the existing position. So it's not as though the bill represents a great new leap into, you know, more extensive use of Henry VIII powers. And the 3 examples where there are new Henry VIII powers, 2 of the 3 of those require consultation. So both of them in the own initiative areas require consultation. And that means that 6 of the 9 powers require consultation before they are used, and they're all subject to the affirmative procedure. And as David and I will have discussed many times here previously, there are different sorts of Henry VIII powers. Some of them are where you have a framework bill, and the Henry VIII power is pretty wide and allows the executive to fill in an awful lot of detail with reasonably narrow oversight by the legislature. And then there are some Henry VIII powers which are much more specific. They're narrow powers. They allow, you know, something to be done in a very particular area. And my reading of the powers in this bill are that they belong in that second category rather than the first. So on the whole, I don't think we do have anxieties about it. If I do have an anxiety, it's about one area where the advice that I've had, and discussions I've had, may suggest that the scope of the power to make consequential and incidental provisions, which is section 78 of the bill, isn't broad enough in relation to the Henry VIII power that it provides, in that it doesn't include a power to amend primary legislation, despite being subject to the affirmative procedure. And we think there may be instances where that would be important. And if it's not there, then we may be in the position of having to bring primary legislation back to the Assembly to put right pretty minor things which would be better done in a more proportionate way.
I mean, I'll go back to this, the issue of section 78 in a moment. But can I, just talk about the Henry VIII provisions, because it was fair enough for you to refer to precedent in terms of the current legislation. But, you know, in general, we don't regard precedent as a sort of, you know, a trump that can just be played and that, you know, is all the justification you need. I think it does need, you know, carefully justified and explored. But, you know, however, we've got to be mindful of that. You know, the powers are, you know, quite significant because we're talking about the sorts of things can be investigated, the criteria, the people on the list that have to be consulted, whatever. And I just wonder, because it was interesting that you qualified your earlier answer on this by saying the new powers that would have Henry VIII powers attached to them require some form of super-affirmative in that there's a consultation on them. Do you think the other Henry VIII powers, where they're applied, could usefully be extended from simple affirmative, which does give a level of, you know, protection, I grant you, but to this requirement to consult as well, and there would be consistency then too?
Well, Chair, I think that 6 out of the 9 Henry VIII powers that the bill takes already have consultation requirements within them. And again, I remember another discussion where I was on the wrong side of Mr. Melding's view when we talked about super affirmative and what we mean by super affirmative and what the ingredients of a super affirmative procedure.
Yeah, they can range, and there's a couple of options really.
Yes,
in terms of super affirmative.
but consultation is generally one of
It is,
them,
yeah.
and in that sense, if you think of a spectrum here, the affirmative powers that the bill proposes are very often stretched towards the super affirmative without necessarily going all the way towards them. And I don't think we have difficulties with that because, for example, in that example of changes to the criteria for own initiative investigations, I think it's a very important power to have in the bill. The Finance Committee went quite a way between the draft and the final bill to put criteria on the face of the bill to shape the conduct of own initiative inquiries. And from the government's point of view, we were grateful to see that and thought that was an improvement on the draft bill. But in something which is new and where even the examples that we are often referred to, for example, in the Northern Ireland context, these are very new there too. And there is no great body of experience built up to know how the rule book for own initiative investigations is best created. So having a power for Welsh ministers to bring forward changes in the light of experience, I think is a sensible safeguard in keeping the bill up to date and in line with what we will know. But it does require that there is prior consultation with the Public Service Ombudsman's Office, if there were to be such proposal. So that guarantees that the National Assembly, in carrying out its scrutiny of those regulations, would always hear not just from the government, but would hear from the body responsible for the investigations as well. And so, in general, I think our view is that the bill is proportionate in the places where it takes Henry VIII powers, because they are generally in those narrow, specific areas, and when there is the need to make sure that the Assembly would have the benefit not just of the government's perspective, but of perspectives of others, those consultation requirements will guarantee that the Assembly has that available to them in the affirmative procedure.
I think Cabinet Secretary would appreciate this as we are rehearsing the ground for the next evidence session that we have as well.
Just finally on this point 78, you've upped the ante a bit by saying you don't think it goes far enough, and that you would like the Tudor monarch to make an appearance.
But Henry IX powers as well.
From our point of view, powers that are necessary or expedient, we don't like the word expedient generally. I mean, how essential is that word from your point of view? And couldn't we trim it to necessary, where we are much more comfortable about these secondary legislation powers being being used under those circumstances?
This has often been an area where the government and the committee have not always seen eye to eye in these sort of consequential provisions. I'll certainly think about the point that the member has made, and I'm happy to write to the committee on that specific point when I've had a chance to do that. The point that I was making a moment ago, Chair, was that the equivalent provision in Section 43 of the 2005 Act, I know you don't deal directly in precedents, but that section does contain a power to amend primary legislation. Let me give you an example of why I think that could be important. Our reading of the bill is, to give you the example, Section 4, brackets 3A of the Parliamentary Commissioner Act of 1967 cites the 2005 Act and requires a consequential amendment. That is not picked up in this bill. There may be references in other primary legislation which require consequential amendment. The power we are seeking would allow us to do that in what we believe will be a proportionate way by using...
But in those examples, necessary would be sufficient, wouldn't it? You wouldn't have to say expedient to cover those examples.
No, I think that's a very fair point to make, and happy again, as I say, to think that through. But without the power at all, we might have to rely on further primary legislation.
Yes, that we accept.
Those sort of things.
Understand that, yeah. Thank you.
Well, I think get to really the end of the session. Are there any other issues or concerns that you feel is worth ought to be drawn to the attention of this committee?
Well, Chair, there are a small number of places where we might want to explore with a member in charge how some aspects of the bill might be amended should it go to the amending stage at the Assembly. I've told you already about putting the power for the Children's Commissioner to consult with the Ombudsman onto the face of the bill. I've told you already about our Section 78 concerns in the power to make consequential incidental amendments. There is an issue at Section 76(1) of the bill, which is a power that is picked up from the 2005 Act, where it is subject to the negative procedure. I think it is suggested that it should be subject to the affirmative procedure in this bill, given that it is a power that simply allows Welsh ministers to ensure that administrative functions of tribunals are treated as such. I don't think we think that it is a sufficient power to require the affirmative oversight of the National Assembly. There are a number of issues which I raised with the Equalities, Local Government and Communities Committee about making consultation mandatory in the case of own initiative inquiries, on where the bar is set as far as private health care services is concerned in recovering costs from them. At the moment, the bar is set, I believe, very high in the bill. You could only recover costs from them where there is an active obstruction of the Ombudsman or a level of non-cooperation equivalent to a contempt of court. That might mean that the public purse is going to be picking up the costs of investigating things that have happened in the private health care sector almost all the time. Just asked that committee whether it wanted to give that consideration. There were some financial aspects of the bill as well, in the way that the RIA and so on has been constructed. I did offer to write to the Equality and Local Government Committee in relation to some technical issues in the way in which oral complaints, investigating oral complaints, is constructed in the bill. It's an example of where we would want to have further discussions further down the line. I'm very happy to copy that letter to this committee if that helps, just to show the sorts of things that that we are thinking about and may need to pick up, you know, once we're in, if the bill is ever in that sort of detailed consideration stage.
Yeah, I mean, that would be helpful. We don't intrude into the sort of policy areas and not our remit, but there may be areas there that...
Yeah, technical and drafting issues, which I think this committee
yes.
does have an interest in, and therefore just I thought it would be useful maybe to
Yes,
share.
that would be helpful. Well, Cabinet Secretary, thank you for your evidence session. You will be given a transcript of the evidence. Thank you for attending today, and to your officials as well.
Thank you very much.
Sorry? If... have we got a gap now between them? So we just adjourn the meeting then for 5 minutes, just waiting for the next witnesses to come. So if anyone wants a quick comfort break or a coffee top up, or... Start. If I could welcome you, Simon Thomas, to the Constitutional and Legislative Affairs Committee. Do you want to introduce your colleagues?
Diolch yn fawr, Cadeirydd.
Thank you very much, Chair. Joining me today are two Assembly Commission officials who have been assisting me with this bill, Joanne McCarthy on the policy side of things and Gareth Howells, who has been drafting the bill from a legal perspective.
Well, thank you very much. And you are, of course, in charge of the bill. So the questions we would want to put to you within the ambit of this committee's responsibilities will be very much focused on the drafting and the specifics of the bill. Perhaps I could ask you as a starting question, general introductory question, why your committee considered it was necessary to bring forward this legislation. What is the background to bringing forward this particular bill?
Diolch yn fawr, Cadeirydd.
Thank you very much, Chair. If I could start by saying that we're very pleased to be back on my old stamping ground on the Constitutional and Legislative Affairs Committee, and I look forward to the scrutiny of this bill. And I am going through it as the member in charge, but this is a committee bill and a bill that's been approved by the Finance Committee, and that's the background to what we are discussing today. Around a decade after the 2005 Act was passed, there was a period of review in terms of how that Act worked. The former Public Services Ombudsman Peter Tyndall drew up a report on what had succeeded in terms of the powers or the new approaches that were required by the Ombudsman. That was considered by the committee, which is now the Local Government Qualities and Communities Committee, but at the time, in the last Assembly, that committee didn't have the time or the resources to proceed with preparing a bill, and therefore in negotiation with the Finance Committee it was agreed that the Finance Committee would take the draft bill through, would consult on that draft bill. That was done by the end of the last Assembly, and then in this Assembly the Finance Committee, when I became Chair, actually took hold of the draft, reviewed it, and looked at it in light of some of the evidence that had been received since then, in the light of some of the conversations that had taken place with the new Cabinet Secretary, who was also new in post at that time. And as you've heard in the evidence that you've just received from the Cabinet Secretary, there were a few changes that were made to that draft bill, and now we have a bill which has been presented as a bill to be discussed by the Assembly, and that's the story behind the bill and why we've reached the point with a bill promoted by the Finance Committee before the Assembly.
Well, thank you for that. It's a very helpful background to the bill. One of the areas obviously we're concerned with is just to scrutinise the issue of competence. Has been certified by yourself as being within competence. I just wondering if you would like to make any comments on the competence issue, because this is, of course, being issued before the coming into effect of the 2017 Wales Act. Are there any issues in terms of competence now as opposed to what the position might be if we haven't completed stage one before the 1st of April?
Cadeirydd, diolch.
Thank you, Chair. I am very confident that the bill is within the legislative competence of the Assembly at the moment, but you are right, of course, to highlight the fact that that legislative competence is to change with the 2017 Act. The bill is based on the previous Act of 2005, but also on Schedule 7 of the Government of Wales Act 2006, and therefore relates to the Public Services Ombudsman in that context. Now, if this bill weren't to pass that point that you mentioned, namely the cut-off point for the new legislative competence, then that would raise some questions on competence in its current form, and we would have to review the bill in the light of that. But I am very confident that in its current form that it does fall within the current competence of the Assembly as things stand.
Okay, thank you. Mr. Dynlloyd.
Diolch yn fawr.
Thank you very much, Chair. Well, as you'll be aware, Simon, this committee can only discuss matters with regard to legislative competence as opposed to policy. So that's the standard to which we adhere here. But can I just ask what consideration you've given to any impact that this bill may have upon human rights?
Can you put a bill?
I think the bill is very important in terms of human rights in Wales because it does impact upon human rights in two specific ways. First of all, the functions of the Public Services Ombudsman itself is an important part of the architecture of human rights in Wales. This is a post that gives people who don't have the ability to present complaints themselves or require support to do that. It gives them a voice. It stands up for people who have suffered some injustice or hardship in one way or another in relation to public services. So the job itself is important within that architecture, but also the bill relates to citizens' rights and deals with the rights of other individuals. So you do need to strike the right balance in terms of human rights. I do need to highlight that the Ombudsman himself is subject to equalities and human rights legislation, the 2010 Equality Act and the Human Rights Act of 1998. And that is included within the legislation surrounding the Ombudsman, and the way that the Ombudsman deals with individuals in turn, I think, strengthens the human rights of the people of Wales and provides greater rights for people to make complaints orally if they don't have the skills to do so in writing. It also gives the Ombudsman the right to express a view or the views of people within what is described as the protected characteristics. So the explanatory memorandum does set out how the bill does impact upon, but I would argue doesn't impact upon negatively, and if anything, makes human rights more accessible in Wales and clearer in Wales.
Thank you very much for that, David.
The Minister feels there is one issue perhaps that needs further exploration, and that's the inevitable retrospection that's involved in if the Ombudsman had powers of initiation. And have you considered this, whether, that, given that the choice of subject and the abilities that come with that, perhaps raise the bar in terms of consideration of human rights issues and this issue of retrospection?
Yes, we have considered that. I think, and I did hear the Minister's or the Cabinet Secretary's evidence, I think we have dealt with that in the bill, and I'd like to set out how I think we've done that. Though by saying that, I'd be very happy to hear what the committee has to say, and also the Cabinet Secretary in its turn to see whether that needs any further clarity. To start with, to say that the Ombudsman, in terms of his work at the moment, has in general a bar or a time limit on investigations. So that's a year. There is a discretion to extend that, as I understand it, under the 2005 Act, but in general, the Ombudsman only goes back over a year's period, and anything that's complained about before that falls out with the Ombudsman's general approach to complaints. But I think the question you asked was more specifically around the own initiative investigations, and I think on the face of the bill, I think it's very clear that we're not looking or seeking to make this a retrospective free-for-all, if I can put it that way. So this maybe reflects some of the amendments we made to the draft bill, to the bill that is now presented, and as a committee we put criteria for own investigation initiatives on the face of the bill. And I think these are the ones that do bring in that protection that you are seeking. So for start, the Ombudsman must be sure that any investigation, own initiative investigation, is in the public interest. So I think that stops, in general administrative law terms, him or he or her going after a long period of past histories, if you like. But more specifically, it not only has to be in the public interest, but also has to meet one of two other criteria, both of which talk about that the matter being investigated is likely to sustain injustice or hardship in consequence of the matter, and then secondly, that systemic failure that may cause any person to sustain injustice or hardship. Now, to my mind, that shows there's an ongoing problem of injustice or hardship. This is not a retrospective power to look at past failures that have been dealt with or the time has passed and has to a certain extent healed. This is a specific power to undertake an own initiative investigation for an ongoing injustice or hardship that is being sustained today. And I think that's the important protectorate there around some sort of long-term, I think what the Minister was talking about was some sort of backstop. I think the backstop on the face of the bill is one that this has to be an ongoing hardship, so it has to be systemic failure that is now ongoing today, not something that's merely related to past history. And I would be interested to see whether this committee and the other committee thought that was sufficient, but that's certainly how we designed the bill.
Can I just ask on that systemic failure point? Because systemic failure almost implies that you're looking at the system, that there are failures there, which means you have to have looked at the system in the past. I mean, it implies retrospectivity. That was the issue that raised with the Cabinet Secretary. But one of the areas of concern of this committee is obviously to scrutinise and to look at the retrospective for all the reasons that we understand. But it seems to me that paragraph 5B there, in terms of own initiative investigations, clearly creates a specific power to be retrospective, because otherwise you can't define the public interest unless you're looking to the history of failure. Isn't that a different interpretation to what you're saying? Because you seem to be suggesting that no, you can't go back, but it seems to me it's implied in the drafting that in actual fact you can, and in fact you must go back. I actually agree with you, and I apologise if there's been confusion, because I'm very clear that if you're looking at a systemic failure, then yes, you are looking back at things that have happened, maybe beyond the current year's ability that the Ombudsman has to look at complaints. But the point I was making is it has to be an ongoing failure. It can't be simply a past failure that was dealt with, by the intervention of a government previously, for example, if you're thinking of a particular health board or whatever it might be. This has to be something that is currently likely to sustain injustice or hardship. So I think the wording of the bill makes it clear that the systemic failure can't be something that's merely in the past, and therefore you can't have the danger of an ombudsman trespassing on retrospective blame game, if you like, on something that's been dealt with appropriately by other officials, other authorities, other regulatory bodies. This is something which the Ombudsman is likely to pick up through either casework, where he sees a pattern of casework, or perhaps it has to be, say, from whistleblowing, where he hasn't had a specific complaint made to him, but he has sufficient evidence, and then the tests are set out on the face of the bill as regards public interest, but he has sufficient evidence to believe there could be a systemic failure here, and that allows him then to undertake an own initiative investigation. So I agree with you, yes, there is a retrospective element to this, but what I am emphasising, however, is that it's not an historic element to this. This is an ongoing systemic failure. He has to, on the face of the bill, he has to demonstrate that that is happening, otherwise he does not have the power to do it.
Thank you, Chair. Moving on to other matters and details, and specifically to ask about the drafting approach taken with regard to this bill, particularly the decision taken not simply to amend the 2005 Act and instead to pursue a new bill. Could you explain the reasons behind that decision?
Thank you. Well, in the strange way that political history seems to repeat itself, I was Member of Parliament when the original bill was passed in 2005, and now I'm responsible for this bill, and the 2005 Act was available only in English, so this is an opportunity to bring forward bilingual legislation in an area which is exceptionally important to public services in Wales, and it was also, in my view, entirely appropriate that we should listen to the work done by this committee when I happened to be a member of it when you published your report on legislating in Wales, and encouraged, rather than making numerous amendments, dozens if not hundreds of amendments in this case to a bill that's already in existence or an act that's already in existence, which would mean that you have to return to that original act, rather than encouraging people to restate the principles in the bill, and that's what we've endeavoured to do here. So this bill does two things, broadly speaking. It restates the 2005 Act and then adds those 4 areas that you've been hearing about in terms of new powers for the Ombudsman and so on. So we believe that we have followed best practice here in adopting this approach. And if I could just add one thing, because there is one section of the bill which is an update on 2005, and that is the section inserted through the Public Services and Wellbeing Act of 2014, and that refers to private healthcare, and it is separate in the bill. And the reason that we haven't tried to include that in the bill, although you would have thought that that might be one possible approach, well, it was only 2.5 years ago the Assembly as a whole decided that this was the way of dealing with this particular section, and we felt that we were overstepping the mark in a way if we were trying to redo what the Assembly had approved unanimously less than 2.5 years ago. That's why the current bill is in its current form.
Thank you very much for that. And another issue that we discuss in this committee traditionally is, regardless of what the bill before us, is the balance of what to include in regulations and what to include on the face of the bill. So the same question applies here. How do you decide what should appear in regulations and what should include on the face of the bill in this particular issue?
Thank you. And most of the balance here did emerge from the original Act. And we have remade this bill based on the 2005 Act, as I've said. And we've done that on the basis of a consultation on the draft bill, and that consultation didn't raise any questions on that approach. And because we felt that parts of the 2005 Act that have been enforced have been effective during that period, we haven't seen too many pieces of subordinate legislation passed as a result of the 2005 Act. There's only 4 examples, I believe. But in addition to that, where we have included regulations and subordinate legislation in this bill, we have done it under the affirmative procedure, again following the recommendations of this committee in terms of how such powers should be dealt with. And I also think it's important to underline that we have endeavoured, and it's always an interesting debate, to strike that balance between what's on the face of the bill and what is possible in terms of future-proofing the bill. You don't always get it right, of course, but generally speaking, we have gone for the affirmative procedure always, and where we needed to state anew, that's, for example, Section 4 of the bill relates to the complaints procedure, which is entirely new. All of that is on the face of the bill. There is no subordinate legislation there. It's all on the face of the bill. So where we were including something that was entirely new and it was possible to put it all on the face of the bill, we did that. And where we felt that we needed to future-proof, or where we felt that we needed to have that debate as time passes and provide that flexibility, we have tried to do it through the affirmative procedure. Thank you.
David?
You say you've made a deliberate choice to use the affirmative procedure. Obviously, you're mindful of what our preferences are and your past service on this committee. But why so many Henry VIII powers, and indeed extending them in terms of where we were with the 2005 Act?
There are several Henry VIII powers. I think there's 9 all told. Allowing the bill to amend primary legislation. I think 6 of them actually restate from the 2005 Act, so we're not completely introducing new powers there. What we're trying to make sure is the bill works for the future, make sure that it is strong enough to do that. We've used the affirmative procedure each time, and I think when it comes to Henry VIII powers, I was watching Wolf Hall once again over Christmas, as it happens, and sort of reminded you they have been part of the British Constitution, unwritten, I know, for quite a long time. There's a strong scepticism about them, I understand that, particularly when they are widely drawn and really allow ministers just to slot in what they like into legislation. But I think these are very specific powers related to very specific parts of the Act. One example allows us to change the listed authorities. Currently, the Assembly is considering the future of CHCs in Wales. So the bill, as it currently drafted, talks about a community health council. If the government were minded and got the support or legislative support of the Assembly to introduce a different kind of organisation in Wales, we would need to amend that. And that is one example of a Henry VIII power. Yes, it is a Henry VIII power, but it's, I think, quite narrowly drawn and very relevant to the purpose of the bill. It doesn't frustrate the bill in any way and doesn't give the Minister any powers to do that. Where we've been able to update the bill without the use of Henry VIII powers, so the current Act also has these powers to amend the listed bodies. One or two rather arcane but interesting public bodies have come to our attention since the passing of the 2005 Act. One of which I'd just like to mention is the Coiti Walia Board of Conservators in the Bridge End area. They are now stated on the face of the bill, so we're no longer relying on the powers, or Henry VIII powers as you might describe them, the powers of the ministers to amend that. Where we've been able to, we've modernised the bill on the face of the bill, but where we feel that there will be a need for powers to amend the bill in future to maintain its relevance to public sector in Wales and the work of the Ombudsman, then we have retained or had introduced, I think, 3 new powers in that regard, and that's the purpose of them.
So I'm just trying to work out what, you know, the theory you've been using then in terms of what's on the face of the bill, and then what, if you put too much on the face of the bill, you need to use Henry VIII powers further down the line. Because, you know, traditionally we don't like arguments that are based on one, well, we're only applying what, you know, was the case before. You know, precedent is not irrelevant, but it's not a trump card either, if we try to improve law. Yeah. But, you know, in general, if so much is changing in terms of the relevance of what's on the face of the bill, you know, the argument surely there should be full scrutiny process through an amending bill, isn't it? I just wonder, you know, what theory you've been operating. I mean, you know, where's the balance? Have you tried to put so much on the face of the bill that you've had to sort of try to counterbalance with the Henry VIII powers, which sometimes we do hear from the executive?
Yeah. I wouldn't describe it exactly like that. So there's been 2 particular quite strong forces on the bill in that regard. We did try to look, this is a slightly separate issue, but it is relevant. We did try to look at, I mentioned earlier, the 2014 Social Services and Wellbeing. We did try to see whether that could be introduced and amended on the face of the bill and taken all the way through. We found that to be, you would get to a position where we found it would be too complex and actually too confusing, and therefore not helpful to have that on the face of the bill. The second element is, and this was a conscious decision of the Finance Committee, we would not seek to amend the powers that were set out in the 2005 Act. So in that sense, yes, we did take precedence and say we will not interfere with that precedence. It seems to have worked well. It seems to be reasonably well accepted. It hasn't led to any serious challenges in any way. So we will take that as face read, if you like. So that gives you, you know, that accounts for 65% of the Henry VIII powers, in effect, you know, 6 out of the 9 emerged directly from the 2005 Act. We didn't try, and it was a conscious decision not to try and do that on the basis that we wanted to restate the Act in a bilingual format and then add these extra powers to it. And that was the overwhelming principle. It wasn't that we didn't have a principle of trying to do things on the face of the bill. It's just when we weighed up these different principles, the overwhelming one was for familiarity, for consistency, for ensuring that we had the clearest possible bill. We'd restate 2005 and then add in the new powers.
Well, you could still have restated it and used a different
yes,
procedure.
No,
you know, it was a choice. Use Henry VIII, wasn't it?
It was. I accept that it was a choice, and I think you know we await to see what the committee's other views on that are. But that's the way we've taken it forward. Yeah.
Okay, perhaps we've gone as far as we can on that. What about the use of some form of a super affirmative then over Henry VIII? That's been kind of compromise position this committee has offered,
Yes.
or urged rather.
Yes.
Would you be happy to extend that?
I think the powers, I mean, a super affirmative, I think, is very important when the powers to amend primary legislation directly could impinge on human rights, could impinge on individuals' position, could impinge on penalties or taxation, as we're now doing, of course, in the Assembly, which we haven't done before, or could take away rights that people had previously enjoyed. I think that's extremely important to have things like the super affirmative, if you are going to use Henry VIII powers and not state them on the face of the bill in those contexts. I think the context of this bill is, I would reiterate, quite narrowly drawn. You could argue in certain terms that one or two of these could appear on the face of the bill. But if you are going to use the powers, then I think the affirmative itself is a very strong sign that the Assembly itself will be examining these. Many of them are linked to consultation. That's not a super affirmative procedure in my view. Consultation should happen where appropriate as much as possible. And if further suggestions come forward about ways of doing that, then we'd be very open to that. But I wouldn't want to confuse the two. I want to be very clear that consultation around an affirmative procedure is not the same as a super affirmative in my view. There is a particular procedure for super affirmative which I think should be kept for the principles that I've set out rather than applied to what is at heart really administrative, important administration, yes, but really administrative, and I think the affirmative procedure in front of the full plenary is a sufficient safeguard there. Now, whether other committees want to suggest some ideas around consultation, around the ways people talk to each other, then we'd be open to that, obviously, but I think that's the key principle that we've tried to apply as a committee here.
Okay, and then finally from me, if we were a little surprised on the Henry VIII approach, given that it's coming from an Assembly committee backed by the Commission, we approach crestfallen on how you're dealing with Section 78, transitional and provisional, I can't remember the exact phrase anyway, but the consequential, sorry.
Yeah.
You say necessary and expedient. And expedient is one of those, red light words that we do not like to see flashed at us because it's, just gives far too much or far too wide a power then. So why not just necessary, given the the traditional view this committee has taken on the use of the word expedient and what the doors that could open?
In Welsh, it sounds even worse, I must admit. Hwylus sounds even worse than expedient in the Welsh version. I very much accept that that's what this committee has had concerns about for a long time over legislation. I will trot out the argument that this does mirror other bills that are taken through the Assembly that won't wash with you. I'm sure that you'll be quite critical of that. Also, as you would have heard, we haven't actually drawn it as widely in this part as government bills, and I think you heard from the Cabinet Secretary that, in fact, this wasn't as wide as he would like it.
He did say that.
We've tried...
He got his retaliation in very early.
We have tried to narrow it down to what we believe to be necessary. We obviously will consider what this committee has to say about those powers. Again, I would say that the other thing that we've introduced here, which is different, is that even these powers are under the affirmative procedure, and that's not happened before, certainly not under a government bill. So even these consequential and transitional arrangements, yes, they're quite wide, but again, they brought in under affirmative procedure, not a negative procedure, which I think, again, tries to follow what this committee has advocated in the past.
If I can just follow one or two pieces, the Section 78, of course, was interesting, and obviously the issue of the use of the words expedient is obviously something we'll look at. But I'd like to go back to the power to investigate own initiative, and this is really just to do with the clarity of the legislation and the clarity of the purpose of the legislation and how it would operate in practice. And that just relates to this issue, and I think the Cabinet Secretary did refer to it. When the Ombudsman is required to consult with other statutory bodies. We have a host of bodies, and I think the Cabinet Secretary's own words were that there was, a difficult enough process of understanding all the different regulatory bodies. But it's a very open power there, which where the Ombudsman is only really required to consult as the Ombudsman sees fit. And that was something I think that raised a little bit of concern, the impact on other bodies and how the legislation might be understood and interpreted and clarity of the function of the Ombudsman. So do you have any thoughts on that particular bit of the evidence?
Yes, and some of that has been reflected in the evidence to the other committee as well in policy terms. I think what we've tried to do here, and I think it is an important point, we've tried to strike the right balance around the independence of the Ombudsman. So I think it's important to bear in mind that the Ombudsman is answerable to the Assembly through the Finance Committee and also through the general scrutiny of the Assembly, which is undertaken by the Equalities and Communities and Local Government Committee at present. He is not answerable to the government. The other bodies about which you talk are regulators responsible to the government or commissioners established by the government and funded by the government. I think we have to get it right, and I'm quite happy to, as a committee, we'd be quite happy to look at any suggestions that come forward from the committee scrutiny process. But to get that balance right is important, I think. I don't want to see the Ombudsman's hands tied around own investigations because some people who in effect are funded by government don't want him trespassing on their ground. I think the Ombudsman must have the freedom to go into difficult places, difficult areas, which may embarrass government, may embarrass bodies funded by government. But he must have the freedom to do that. Now, whether that is captured correctly by the current wording, as I say, we're very happy to consider alternatives. But I think that's why it's important to say that's why it's left to his discretion in terms of how he consults and the way he consults. It's to ensure that there isn't undue pressure put on the Ombudsman's office by those who had something to lose if he were to undertake an investigation that is needed to undertake. And we go back to the earlier point of this legislation, which of course is around citizens' rights. It's about strengthening the voice of the most vulnerable in our communities and about really giving a voice to people who struggle sometimes to get their concerns heard by public bodies in Wales.
So you don't rule out whether there might be benefits, though, to at least looking at the issue of notification or consultation in some way, even if that didn't hamper the ability of the Ombudsman to proceed with what he'd decided was necessary?
No, correct. And in principle, the Finance Committee would be open to look at that. And the reason I say that quite clearly is that the draft bill didn't have any of this on the face of the bill at all. So the draft bill completely left own initiative to the Ombudsman's discretion. We thought that that was too far in one direction. You're quite right. So we did drag it back a little, put on the face of the bill the criteria for that. If that needs clarity, then that's something we can consider as a committee, and we would want to consider that as a committee. But I just wanted to underline why it's there, so that we don't set hairs running about the Ombudsman somehow is going to be a different beast to the rest of these bodies. He is a different beast. He is very much independent of those bodies and should not be hidebound by what the Welsh Government has to say or the other regulatory bodies have to say. He's there on behalf of the individual citizen, not on behalf of government. And I think that's the difference here.
No, well, thank you very much for those comments. Were there any other matters that... Can I ask you if you've got any... I mean, you will have heard the Cabinet Secretaries, I mean, the unusual position of not being in charge of the legislation, but commenting on it. Were there any issues that were raised by the Cabinet Secretary that you wanted to raise? I mean, if you don't want to raise them orally now, you wanted to think about them or scrutinise the transcript, you could write to us on that. But is there anything immediately that comes to mind that you would want to raise now?
I think just in general, I'll by all means follow up if we look at the transcript and feel we didn't quite hear all of it, I must say. It was quite quiet. So we might want to follow up on some of that. But in general, towards the end, the Cabinet Secretary mentioned a couple of amendments that he was seeking to explore with me as the member in charge and with the committee. Of course, we're very happy to try and do that, and we'd want to try and underline, do the best we can in working with the Cabinet Secretary. You're not a policy committee, but you also heard him say about the general policy intent and his view on that. And of course, we want to get Welsh Government back in for this bill as it will not be possible for us to take it forward without a financial resolution or without the necessary discussions that only government can really do with other governments, for example, and with other parts of the infrastructure, if you like, around the other commissioners, the other people in Wales. So I'm very open for those discussions. If there's anything specific, then of course we'll follow up. The other thing I think I'd just bring to this committee's attention, if I can get the thing correct, that section, this section 25, isn't it? Describe it correctly. Section 25 of the bill, non-action following receipt of the report. It has been brought to our attention that this section, which replicates the 2005 Act, has never been brought into force and is, in fact, probably superfluous. And I think the other committees received a report from the School of Law in Liverpool University around this. So it's just to flag up, because this committee might have an interest in that, to say that subject to the evidence, that is one area where we might be minded to withdraw that section, because it in effect has no power. It has no relevance to what the current infrastructure in the Ombudsman is. But you can see from the evidence of why that has come about. Okay, well, thank you for the evidence and the clarity of evidence that you've given, and for the work of your officials. Transcript will be with you in due course. If there are any further comments, well, of course, we look forward to receiving those. Thank you very much. Diolch yn fawr iawn. Diolch. Now going to private session, is it? Okay, in accordance with Standing Order 17.42, invite the committee to resolve to exclude the public from the remainder of the meeting. The members agree?
Content.
We now move into private session.